Rep. Watson Coleman, alongside two of our colleagues, founded the Congressional Caucus on Black Women and Girls, the first caucus aimed at bringing both the tremendous challenges and incredible successes of Black women to the fore in Congress's policy debates. And with that, thank you all so much again for joining, and I'll turn it over to you, Damon.
Thanks so much, Sydney. Thanks to our great team at the Lawyers Committee, and thanks to you and the audience and all of our speakers today. I'm excited for this conversation, and I will lead off this first part with Congresswoman Bonnie Watson Coleman. We're here today talking about the Crown Act. It's an acronym, as many may know, creating a respectful and open world for natural hair. At the Lawyers Committee, we talk a lot about making the promises of our democracy real. We mean that literally in terms of voting rights. We mean that in terms of fighting for safety from racist violence and police violence. We mean that in terms of economic opportunity, educational access, but we also mean it in terms of self-determination and simply just being, freedom and liberation. And in many ways, we believe that's what the Crown Act is all about. I'm so excited to have this conversation with Congresswoman Bonnie Watson Coleman, and I want to turn to her to ask her a few questions. And if we have time, we'll also entertain questions for her over the next, in the next 20 minutes or so from the audience, in case you have questions for her as well. Congresswoman Watson Coleman, welcome.
Thanks for having me here. I'm very pleased to be among you all today.
Fantastic. Well, and we are honored, thrilled about what you've been able to accomplish as the lead sponsor of the Crown Act. Can you just tell us what are the basic pillars of this legislation and what would it accomplish?
It would accomplish something on a national level that has been already passed on some of the state levels. It would protect women and children and men and boys from discrimination in various arenas because they have natural hair, because they wear it in a way that sort of is Afrocentric, or it is different than European standards of what's pretty and what's not. And it would protect individuals either in the job, in the employment world, in the educational world, and even in the housing world, and even in public accommodations. And it protects them even in programs that are funded with federal dollars. So it creates a respectful environment. Of course it does. Hopefully it becomes an educational aspect so people can, you can appreciate the beauty and the majesty and the sort of uniqueness of the hair, and still not miss just how brilliant the person whose head that hair is on is. And it just it's another level of discrimination that needed to be addressed, because either women were feeling compelled to change their hair, cover their hair in the work environment. Children were being overly disciplined in the educational environment. Men were reacted to in the employment environment. And then people, even in housing and public accommodations, had a reaction. In some instances, an action occurred that was directly related to the fact that they had locks or bantu knots. I mean, I'm so reminded of the young man at the wrestling match, who before he was allowed to participate in the match, he had a white referee decided that his locks were inappropriate. And so in front of the whole gymnasium of people, this young man, this young boy, had to have his locks cut. And I guess the thing that gives me the greatest pride is that then he went on and won that match. And so even though he had to face that humiliation, he went on and he won that match. And we just passed this act in the House of Representatives a couple of weeks ago. And just recently I saw another illustration where a woman had to unlock her hair or get rid of her, whatever she had, before she could participate in a powerlifting contest. And so this is a means, as far as I'm concerned, of educating, holding accountable, getting information on this so that we could do other things that may require a response, but it also is a civil rights protection.
Mm-hmm. Well, thank you. And I love that the comprehensiveness of this legislation is covering various facets of American life, of Black life, in various contexts, from schools to the workplace and so many places in between. We've seen, and we're just talking to our team today about a parish in my home state of Louisiana where a former sheriff said, if you come through here wearing dreadlocks and certain hairstyles, you're going to get a visit from a sheriff's deputy. So we know that these things lead to racial profiling in the policing context, but all other kinds of contexts as well. So, what called, well, I guess let me ask this, why is this legislation so important now? We've been in the midst of what I call a protracted movement moment. I think it's more than a moment. We've seen that there have been shifts in public discourse, and we've seen some efforts for policy shift. We've also seen a lot of retrenchment, right? The attacks on critical race theory, even when it's not really critical race theory, which we're soon over those as well. The attacks on affirmative action, on voting rights, what have you. So why is the Crown Act so important in this moment where, whether you call it consciousness or wokeness or what have you, that so many folks, really multiracial coalition, is really flexing its muscles and having its voice heard?
We're coming out of a very harsh, evil, mean period at a time when people who already harbored these sort of tendencies, these biases, now felt empowered to act on them. And this whole issue of who's different and the other has just created such tension and insecurity and challenge to our safety and security that this bill just represents addressing an aspect of it. There's so much work that we have to do. This is a part, we have a right to be who we are. We have a right to wear our hair any way we choose to wear it. It is part of our identity. It's got nothing to do with that job that I can do, or that course that I can take, or that school that I can attend, or whatever else. And so it's sad that in 2022, we're down to this now. At the same time, we've got so many other aspects that are challenging our civil and human rights and this concept of democracy that's supposed to work for us as well. So I think that it was important for this to come up now, because it is highlighting again another barrier to our access to be who we want to be, ascend to where we're going to ascend because of our intellect and our hard work, and to be protected. And so those folks need to know there are consequences. Now there are going to be consequences. There'll be consequences when the Senate takes it up and passes it, because the president, he's ready and willing and able to sign it.
That's right. No doubt, no doubt. So this isn't the first time I understand that you've sponsored this legislation. What called you to be the lead sponsor?
So Cedric Richmond was the lead sponsor in the last Congress. And in the last Congress, this bill passed without controversy. It didn't have all the Republicans on it, but it just passed without controversy. He went on to take a job in the administration. And my whole life has been about working in the civil rights field. My very first job was working with the Division on Civil Rights. Every job that I had thereafter in the executive branch had something to do with civil rights, affirmative action, equal employment opportunity, and things of that nature. And so even as a state legislator, I worked in that realm, whether it was prison reform, sentencing reform, housing, equality. So that's kind of like who I am. So when Cedric went on and the bill was kind of hanging out there, I reached out and said, please let me be the prime sponsor this time. It's in my wheelhouse, it's in my heart. And I promise you that I will treat it with the dignity and respect and continue to push on until we try to get to where we need to be.
It's fantastic to see that connection. Cedric's my former high school classmate.
Oh, wow.
from New Orleans. So that's fantastic. He's doing great things in the administration now. So let's shift gears a bit and talk about the path, right? You said it passed without fanfare in the last Congress. In this Congress, we saw people like the gentleman from Ohio, who I will not name, you can name if you want, having choice things to say, trying to belittle this issue, which is so much a part of our identity as a culture and as a community. So tell us about the fight, what it took to get this legislation passed, to get everyone, even in your own caucus, on board with this.
Well, it took tremendous restraint on the part of those that had to interact with the folks on the other side who were being disrespectful and diminishing the significance of this, or even having any legitimacy to speak in this realm, because you don't know, and you don't care, and you've not demonstrated that you're there. So it was very frustrating when we brought it up under the consent practice and it didn't pass. Then we knew that we had to bring it up through regular order, which required it going through the rules committee and then coming back on the floor and then needing just a simple majority. Well, I tell you, the leadership in the House of Representatives came up to me immediately and they said, regular order, we'll do this regular order. And so I didn't feel that I had the challenges in my caucus to get this bill passed. And I never expected a whole bunch of Republicans, although, about 13 or 14 of them did come on board. There was a debate on the bill, and it was an ugly debate on the bill. And the person who spearheaded the debate on the Republican side just talked about totally irrelevant things and then tried to diminish the significance or importance of passing this piece of legislation and recognizing that this was an anti-discrimination legislative piece. And then when we voted on the floor, we had a member who referred to it as the bad hair bill when she was advancing the proxy vote for someone else. And I just kind of went over to her and introduced myself to her and asked, did I misunderstand what you said? And so she kind of cleared it up a little bit, saying, oh, I wasn't saying it was a bad hair bill. I was saying it's a bad hair bill. I mean, it's a bad bill. It's just, we didn't need to do that hair bill. And I said, well, I disagree with you, but I'm a little bit more comfortable with the fact that you weren't referring to whether or not the hair was good or bad. Listen, we were joyous when the bill passed. It is a step in the right direction. We're not there yet. We've got to get through the Senate.
Right. We do. Well, look, what you just said, I don't know if my emotions are transparent on the screen, but it made me angry because we know that this whole thing, bad hair, that's code for, in-house conversations and hurts within the Black community. And you're more gracious than I may have been.
Well, I explained to her that these were toxic words, that they communicated something to us, and that I just needed to hear from her that that's not what she meant. Because, and if she had not sort of retreated from it, I have no idea, because I was angry. I was angry during the debate with the person who led the debate. I look at, that person and the things that he's done and been accused of and been involved in, and you're up there trying to speak righteousness about anything. But that's what we're dealing with right now. That's emblematic of what that side looks like right now, unfortunately, with the exception of a few.
That's right. Well, it seems to me that I don't want to shift the focus at all, but I just want to say that what we're seeing from the comments from the opposition to all the horrible incidents that have happened around the country. I see here in the chat that someone, Ellen Reddy, our good friend from Mississippi, who who's not a lawyer but taught me how to lawyer with community, said the same thing happened in Rankin County, Mississippi during a powerlifting contest. But,
that's what I was referring to.
Right, exactly. So, not to deviate from the focus, but there's a culture war happening in this country right now. And in some ways it hasn't ever stopped, but it seems to flare up at times when there is stronger Black and brown electoral power, in terms of voting, in terms of being in office, in terms of holding certain positions, in terms of trying to shift culture in a progressive way. In so many ways, what we're seeing is a reaction, including the attacks on critical race theory, a reaction to what happened in 2020 in terms of the presidential election and also the congressional races and state races in certain states like Georgia and elsewhere, but also reaction to the fact that we were building coalition by kind of broadening the circle of concern, by getting corporate interests and multiracial and interfaith interests on board with the agenda for racial justice. And so this is just like, in many ways, trying to ban books, trying to set us back, trying to divide us, but with a really unique and pernicious historical context of attacks that can be framed as anything, cannot be framed as anything but racist. So in terms of go ahead, I'm sorry, you want to say something?
I was just gonna say, in my mind, I mean, you saw things kind of creeping up in a way that was creating a tension and a divisiveness, but it really kind of blew up under the last presidential administration, and it was encouraged, and it even preceded our having been so actively engaged. You could point to us and say, man, Black women made that happen. Man, Jim Clyburn made that happen. Man, Black folks got together and made that happen. It even preceded that. Now, he's gone, but what you're talking about, the actual like residuals of what he started, this cultural war, is very damaging and very dangerous. And it's dangerous to fundamentally to democracy. And we never, ever, ever thought that we would encounter this sort of flagrancy of it at this time. We thought we'd been there with hoses and dogs and things of that nature. But we got to be careful because we're very close to being just there.
Right. There's no doubt about that. We have to remain vigilant. So in terms of prospects in the Senate, I understand your counterpart in the Senate in terms of responses, also from New Jersey, Senator Cory Booker, a good friend of the Lawyers Committee and the Civil Rights Movement, and a fan of most of America right now for how he so ardently defended soon-to-be Justice Ketanji Brown Jackson. So what are we looking for in the Senate in terms of prospects for passage? And are there certain things we should be watching out for? How should we be deploying?
See, I think that we should be reaching out to Cory Booker. I adore him. I love him. We work very closely together. I think he needs to be asked, when do you think that we're going to be able to advance this on the agenda? Where do you think this is at? Are there any particular one or two senators that we need to talk to?
Right.
I think it's going to be a heavy lift over there because the Senate is just a very strange place right now. Mm-hmm. We have the chance to eliminate the barriers to getting things done in the Senate, but we've got two holdouts from the Democratic caucus who are standing in the way of doing exactly that. So I don't think it's going to be easy, but I'm hoping that there are cooler heads that will prevail over there. Huh. However, when I saw what happened with what I can call the Inquisition of Judge Brown Jackson, mm-hmm. I wonder, because unless we're able to advance this without the filibuster and stuff, we're going to have the same evilness manifested on something like this, which right. harms no one.
Right. I think that's right. And we certainly will, and I'm sure other of our speakers and people in the audience will be reaching out to Senator Cory Booker as well, but also Senate leadership, which is Democrat control right now, I think is important. We've done the same on voting rights and so many other issues. They have to hear from us that this is important to the Black community, that's important to our allies, that it's important to us as civil rights organizations and leaders. And so we'll make sure to keep up that drumbeat. So we have other people sharing in the chat. Sheree Oates also from from Mississippi, talking about someone in Bruce, Mississippi. I believe it's the same county. There's so much lived experience and lived trauma, quite frankly, having to do with our natural hairstyles. And there's so many people who have all of these examples, right? All these local examples. So there's local trauma and harm, but there's also local leadership. How can people who are, whether they're politically active or in an organization or not, how can they lift up their stories and be part of this movement?
Well, first of all, I think it would be very good if they lifted up their stories on any social media platform, and that they let those folks in the Senate, in the US Senate, know. So that, because I think that it is good that these bills are being passed in certain states, but we need protection from a national perspective. So we need to see those. We need to be reminded of just how critical this issue is. And it's, so adults can react in a certain way and we can kind of get over it, even though we had to put a wig on our head because we had to hide our braids to go to work. But children in our schools were overly disciplined when there's an option not to discipline them, it's just very discretionary, and they're disciplined for things like dress code and unapproved hairstyles, things of that nature. We got to stop letting our kids get bruised. We got to stop it, because our kids are traumatized on so many levels, and we just got to start dealing with that whole mental health issue. Let me say this, because I do have to leave. One of the things that the Congressional Black Caucus, at the Caucus on Black Women and Girls in particular, we just released a report that was basically put together by some really smart researchers, academics, and other folks, called Black Women Best: Economy for All, a great economy for all. And what it says about, if we would take Black women out of the margins of the policy discussions and the legislative discussions, and we would center their life experiences and hear from them their stories, and center our policies and our legislation to address those systems that have created the barriers for them, then everybody will benefit. And so if you ask me what's next, getting this act done, the Crown Act, and signed into law, but then getting people to think differently about how you craft, how you envision public policy and legislation, and how you seek to change systems. And so I'd like to talk about that one day too.
Fantastic. Well, Congresswoman Bonnie Watson Coleman, thank you so much for being with us. It's a pleasure. Love to see what you're doing. You designed legislation and champion legislation that defends and protects, but it also builds. It builds a space for us just to be us, for people to be free and to live liberated. Thank you so much for being with us.
Thank you, and thank you for devoting time to this. Thank you. God bless.
Thank you. Well, people keep adding your comments to the chat. We'll make sure we record that and share everything. I want to now introduce my great colleague, Phylicia Hill, who's been one of our great internal champions of the Crown Act legislation. She's currently counsel in our criminal justice practice, but she was previously counsel in our economic justice practice. So I love her integrated mind, how she sees across these issues. I'm going to turn to Phylicia to introduce our amazing panel that will be with you for the remainder of this discussion. They are all friends and colleagues, some of them for more years than we care to note, but they are among the nation's leading experts, advocates, scholars even, on this important work. Phylicia, over to you.
Thank you. Thank you so much, Damon. And I wanted to say thank you again to Representative Watson Coleman for taking time out of her busy schedule to be with us today to discuss the Crown Act. As Damon said, my name is Phylicia Hill, and I'm counsel on the Criminal Justice Project here at the Lawyers Committee. But prior to this role, I was counsel on the Economic Justice Project, which, among other things, worked in coalition on the passage of the Federal Crown Act. And I'm extremely excited about the conversation that will be had today amongst our panelists. And I hope that everyone leaves this webinar informed and empowered to start or continue advocating for the passage of the Crown Act in the Senate and eventually to have it signed into law. As you're listening to our panelists speak, I just want to remind you that if you have any questions, to please put them in the questions box so that we can hopefully address any questions that you have during today's discussion. So without further hesitation, I'm going to introduce our panelists so that we can begin. First up, we have Professor Wendy Greene. Professor Wendy Greene is a U.S. anti-discrimination law scholar, teacher, and advocate. Professor Greene crafted the legal blueprint for the Crown Act, which has also shaped the enforcement stance of the Equal Employment Opportunity Commission, federal courts, administrative law judges, and civil and human rights organizations. We're also joined by Joi Chaney, who is the Executive Director of the Washington Bureau and Senior Vice President of Policy and Advocacy at the National Urban League. Having served in the equal employment spaces, including the Office of Equal Employment Opportunity Commission under the Obama administration, Joi, fiercely advocates for the Crown Act as necessary legislation. We are also joined by Cylar Barrett, who is the Director of Policy at the NAACP Legal Defense and Educational Fund, where she leads the work on advancing the Crown Act and other critical civil rights priorities. And lastly, we're joined by Brenda Morrison, who successfully advocated for passage of the Crown Act in Broward County, Florida, where she is currently completing her graduate degree while interning for the Lawyers Committee. So I want to thank all of our panelists again for joining us today. I'm going to start with Professor Greene. Professor Greene, could you please tell us more about why current civil rights statutes do not protect against discrimination on the basis of Black natural hairstyles?
Sure. Thank you so much, Phylicia. And again, thank you all for allowing us to be a part of this really important conversation today. So I will just kind of give you an overview of the past 40 plus years in very, very short period of time. And to the best of my ability, even maybe the past 400 years as it relates to the lawful racial discrimination on the basis of our natural hairstyles. As you know, that our natural hairstyles are very much a fundamental part of our expression as it relates to our cultural, our social identities, our personal identities, and even sometimes our religious identities, and has been a basis for racial enslavement and racial apartheid and exclusion in this country and around the world, frankly. But I will say, fast forward into the 20th century / 21st century, what has happened is that we have, a plethora of Black women and men who have been challenging natural hair discrimination, natural hair bans in our workplaces, namely as it relates to discrimination on the basis of afros, locks, braids, twists, bantu knots, even braids with beads, and even sometimes Black women who are donning blonde hair in terms of the ways in which we're showing up in the workplace. And so very early on, or shortly after we have the passage of the Civil Rights Act of 1964, we see Black women and men challenging these discriminatory grooming policies that regulate our natural hairstyles, and then as a form of race discrimination under our federal civil rights statutes. And so beginning in 1981, we start to see federal courts creating what I call a hair splitting legal distinction, which basically in these cases challenging natural hair discrimination as race discrimination. And in these race-based grooming codes discrimination cases, federal courts were adopting their own doctrine that they created, known as the immutability doctrine, which is that basically our civil rights protections against race discrimination would limit discrimination on the basis of immutable or unchangeable characteristics, or characteristics that we're born with, or characteristics that are only going to be possessed by individuals of a particular racial group, which really there are none, right? Because we know white people who can rock afros, we know Black people who can rock afros. So there's not, and have light skin and so forth. So there's not one characteristic that only Black people possess and white people cannot, and vice versa. But nonetheless, based upon this immutability doctrine and the kinds of ideas about race that are shaping this immutability doctrine, we have courts basically viewing afros as an immutable characteristic of Blackness, and any hairstyles that flow from our afro hair texture as mutable cultural characteristics. right? And so since Title VII does not prohibit discrimination on the basis of culture, what does that really mean when you see people being discriminated against on the basis of their locks, braids, and twists, and Bantu knots, and not afros? What it really means is that over the past 40 years, federal courts have basically used this immutability doctrine to say that when a person is discriminated against on the basis of an afro, then that constitutes unlawful race discrimination. But if you lock, braid, or twist or not that afro, then magically is no longer about race, and it does not constitute unlawful race discrimination under our federal civil rights laws. And so what that means is that employers can essentially discriminate against Black people who are wearing natural hairstyles as long as it's not an afro, right? So this is like the creation of this, hair splitting legal distinction that is really nonsensical, is unjustifiable. And what essentially what it means is that the Crown Act really helps to cure this unjustifiable and nonsensical gap in civil rights protections that federal courts have reaffirmed repeatedly for over 40 years, and most recently in a case, EEOC versus Catastrophe Management Solutions, where in the 11th Circuit Court of Appeals upheld an employer's decision to rescind a Black woman's job, her black woman's job offer as a customer service representative because she refused to cut off her locks. And what the court did is they reasoned that the employer's prohibition against a locked hairstyle did not violate Title VII's protections against race discrimination, because locks are a mutable or changeable hairstyle, rather than an immutable or unchangeable hair texture like an afro. And so this is where we are, that really serves as the legal impetus for the Crown Act, really trying to cure what, again, I call a hair splitting legal distinction, which has really left countless individuals, countless employees, Black women and men who are working in private spheres, among other spheres, to racial discrimination on the basis of our natural hairstyles. And what this legislation really attempts to do is to cure this nonsensical and unjustifiable and frankly a very harmful gap in civil rights protections against racial discrimination on the basis of natural hair discrimination, and really attempts to provide more comprehensive legislation to attend to what we know is a very systemic form of discrimination that we're experiencing in our workplaces as well as in other spaces in our life.
Thank you so much for that, that overview and that discussion. And I think that sort of nicely leads into a question that I actually have for Lisa Cylar Barrett. Lisa, I know that LDF is one of the leading civil rights organizations challenging discrimination against Black natural hairstyles. Can you share a little bit more about some of LDF's clients and what they have experienced and the work that LDF has done in that space?
Sure, and thank you, Phylicia. I first just want to say thank you to the Lawyers Committee for hosting this webinar today. It's such a critically important issue, and one that LDF is intimately involved in. From our consulting with key members or leaders of the Crown Coalition, which I know a number of us are a member of, such as Advocacy and on the language for the legislation at the state and federal level, but also our litigation on this issue. Consistent with our mission, we've been on the front lines of opposing policies that have a discriminatory impact on Black people because of specific characteristics, including hair type and hairstyles. We really see these characteristics being used as racial proxies to limit the mobility of Black people in public and private spaces, and to strike at the freedom and dignity of Black people. And so we recognize that anti-Black racism takes on many forms, and one of the persistent forms is this issue of targeting Black people based on their hair texture and or styles, as Professor Greene just laid out beautifully, that are linked to Black identity. And policies and practices that target the natural texture and styles of Black people are discriminatory because they are intimately connected to a protected class of individuals and are often derived from really invidious stereotypes regarding Black people. So for years, Black Americans have been subjected to financial, psychological, dignitary, and other harms created through the policing of these inaccurate stereotypes. And in the last few years alone, LDF has challenged a hair policy in a Boston area charter school that denied Maya and Deanna Cook the right to wear braid extensions at their school. We challenged the incident that Congresswoman Bonnie Watson Coleman referenced, in which Andre Johnson, a Black high school student in New Jersey, was forced to cut his hair in order to compete in a high school wrestling match. We filed an administrative complaint with the Florida Department of Education on behalf of a 6-year-old who was denied entry into the first day of school because he wore his hair in locks. And then I think most recently was the case in Texas on behalf of our client, Mr. DeAndre Arnold, who was told that he would be required to cut his locks or would no longer be able to participate in regular classes and school activities, including his graduation ceremony. So we have seen and challenged, this issue of hair discrimination or discrimination using hair as a proxy in many instances in the education context and in the employment context. And so when you look at the legislative text, it is really crafted and tailored to get at this issue that Professor Greene was laying out in terms of identifying the hair textures and the styles that are associated with either the natural hair or the culture of Black people, so that we get at this issue of using hair being used as a proxy for race. Racist stereotypes about the appropriateness and acceptability of Black hair continue to permeate social environments, including school and work. And it's deeply disturbing to LDF, as I know it is to my colleagues here, that Black citizens still must fight for undisrupted and unbiased opportunities. And so we are thrilled that this legislation did not die as our friend Cedric Richmond moved to the administration, and that Congresswoman Bonnie Watson Coleman sort of picked up the mantle and are ready to really push the Senate to move this legislation forward, because it is really important and critical. Thrilled to see the advancement of legislation in the various states, but we do need to address this on a national level, and we need this federal legislation.
So we've talked a lot about sort of why the Crown Act is important and the history of why we need this particular legislation. But Lisa, I'd like to hear just a little bit more, if you could explain, especially for our audience members who may not be aware, how exactly would the Crown Act protect Black people and other people of color if it's enacted? And as you're engaging in that discussion, could you also sort of discuss what you view as the pathway forward in the Senate for making sure that this legislation is passed in the Senate?
Yeah, so I mean, the legislation specifically would provide remedies for racial discrimination on the basis of, the hairstyle. Again, getting at this issue of hairstyles and texture or discrimination regarding people's hairstyles or texture being used as a proxy for race. And so, as I said, when you look at the legislative text, it really does address this issue of things that are intimately connected to our culture and the texture of our hair. And it would provide, many of the same remedies that we see in the other statutes regarding racial discrimination in terms of protections in the employment context, protections in the educational context, allowing or again, allowing folks to seek redress and appropriate remedies when they are experiencing this issue. It also, would explicitly mandate that workplace and policies and school policies are developed and applied in a non-discriminatory manner. So it makes very explicit that hair discrimination or discrimination based on these issues related to hair is a real problem, and that it is disproportionately impacting people of color. And then as far as a path in the Senate, I think, we all know the challenges, and certainly, I'm looking at Joi, and I know your colleagues at the Lawyers Committee, we've been fighting on many fronts on the civil rights agendas, from voting rights to, this most recent fight regarding the Supreme Court nominee. And one thing that our president and director counsel emeritus said about a year or so ago is that, we know the same shoulders that we stand on. One thing that we know about that is that they never gave up, right? That you don't just quit in a civil rights fight. So we will be working with Senator Booker and other allies on the Senate side to determine how we can move this legislation, this really important legislation, and doing some education with folks to help them understand why it is really needed. And then I think the other piece, and I think Brenda's probably going to talk about this more, is that we need folks throughout the country to really lift their voice about the need for this legislation and to join us in the effort, right? That's when the Senate is responsive, when they are hearing from folks in their states, and when they feel there's some political or some price associated with their inaction. And so we need to make sure that folks feel that they need to take the steps necessary to make this important legislation law.
And before I transition to Joi, I do notice a question in the audience asking if the Crown Act would apply to whites who wear braids as well. So if anybody wants to address that question very quickly.
Sure, I do. This is a question that you get a lot because I think what happens oftentimes with civil rights legislation, especially as it relates to racial discrimination, is that so many people sort of perceive it as only protecting, say, Black people or people of color from racial discrimination. But we know with all of our civil rights laws, namely our federal civil rights laws, like the 64 Civil Rights Act, Section 1981, though grounded in African descendants' experience of discrimination and exclusion and oppression in this country, it ends up protecting everybody, right? It protects everybody from not only racial discrimination, but also other forms of discrimination. So I say that to say is that if, for example, a white person was, and this happens, it's not to sit here and say it doesn't happen, if they're wearing locked hairstyles, and the theory is that they are discriminated against because those locked hairstyles are too Black, right, or associated with Blackness, and serve as the basis of a negative adverse employment decision, then yes, it's not just only the Crown Act would help to amplify their claim of racial discrimination, but just more generally, our federal civil rights protections under Title VII against racial discrimination would, right? And so because essentially what that means is that this person is being discriminated against on the basis of a negative or pejorative racial stereotype. And those types of stereotypes should be eliminated from our employment decisions, regardless of one's racial identity. Similarly, without the Crown Act, or even with the Crown Act, if a white worker, they were wearing locked hairstyles or braids and in the workplace, and if only they were targeted, right? So say, for example, other people, regardless of their racial identity, are allowed to wear locks or braided hairstyles, and they were treated differently, then we know that's like a bread and butter kind of claim of racial discrimination, because you're being treated differently, you're being targeted and excluded. So therefore, you would have, again, an actionable claim of racial discrimination with the Federal Crown Act, as well as without the Federal Crown Act. But the main issue has been that for Black people who have been wearing natural hairstyles and are discriminated against, that without the Crown Act, unless they're Afros and they're being discriminated against, they would not have protection under our federal civil rights laws if those federal courts are applying, as I mentioned before, this immutability doctrine and limiting racial discrimination to instances of discrimination on the basis of Afros.
And Phylicia, I'll just say, you know, when you asked the question, I smiled, you probably noticed, and Professor Greene smiled also, because as she mentioned, we get this question often. The reality is that while it would apply to someone white wearing braids, the reality is that those cases would be few and far between. The majority of these cases are really Black people that are facing this issue, and that's what the legislation, you know, what we're hoping will address. These large repeated instances of discrimination that are being experienced by the Black community.
So we've talked, or we hear, I think, a lot about the instances of hair-based discrimination in the education context. I think Damon and Representative Watson-Coleman spoke about two instances that have made national headlines, but we know that hair-based racialized discrimination also happens in the employment context a lot. And so, Joi, I want you to talk a little bit more about what this looks like in the employment space. You have worked extensively on employment law issues. And so could you tell us a little bit more about the risk of discrimination in the workplace without the protection of the Crown Act, particularly for Black women and other women of color? And one thing that has come up a lot when we were working on the Crown Act, and comes up a lot in these conversations, is around the use of hair-based discrimination as a pretext for other types of racialized discrimination. So if you could talk about that a little bit more in depth and give us greater context for that, that would be great.
Absolutely. Well, first of all, thank you so much for inviting me to this panel and allowing me to join all of you. And I want to give a special nod to Brenda, who is a part of our Broward County YPs, Young Professionals, and they've been doing some work around this issue, and I hope that she will highlight that. If not, I will certainly do so. So, you know, you're right. Phylicia, I have been working on this issue when the EEOC versus CMS case was coming through. I was at the agency. One of the priorities that Jackie Berrien, former deputy at leadership, at LDF, cared a great deal about. She was chair, I worked for her. One of our priorities was reducing barriers to employment. And one of the barriers to employment for Black people is discrimination on the basis of hairstyle. It seems almost ridiculous, except I'm willing to put good money on the fact that each and every one of us on this call has had hairstyle factor into our decision-making or our thought process. And preparing for today, and around the time contemporaneous with the locks case, I remember I couldn't talk about it then, right? Because it was not fully public. But I can remember going to my brother's business school, and there was a young lady who was his one of his fellow students who had just said she was bemoaning the fact that she took her braids out. She had just put them in and spent $200, which was a lot of money for an MBA student, and she had taken them out because she got a surprise interview, and she knew. And matter of fact, it was told to her by even a professor. Suggested that she might not want to go in with that hairstyle. So she blew $200, took her hair out, and then tried to have to find another way. And I remember being heartbroken at her having to waste those resources, but really having to waste that emotional energy. on her hairstyle. Now that was years ago, and now it seems ridiculous. We have Ketanji Brown Jackson. We don't even talk about her hair, but this, woman with this beautiful natural hairstyle, who was soon to be Justice Jackson. But at the time, just a few years ago, it was a huge deal. And I can remember how significant it was. And so, yeah, I mean, this in the employment context, I think for most people, most African-American adults, that is how we have experienced it. Whether in reality, we were dealing with discrimination, or just the specter of dealing with discrimination in European standards for not just what is beautiful, but what is professional. And so it is definitely often a pretext for other adverse employment decisions on the basis of race, and can absolutely be where, prior to there being so much attention around it. I would be interested to know how much people and where people are still experiencing this as our standards have changed for what's professional, thank goodness, but we know we need a law, because there are some people who are outside of that, right? And who might be using views of what's professional, views of what is accepted by certain customers, right? What your customers may expect to see. Oh, I'm not discriminating, but our standards and more. So I'll give you an example. The law firm I was in, one of our managing partners, maybe I shouldn't say all that, but she, would change her hair, right? If she had a court case. And her excuse for it was, look, I'm representing my client, and I don't want my client to be adversely impacted by people's view of what I should and should not look like. So we're always making those decisions, but where do we go from where we're making those decisions on our own, so to speak, and where our employers are kind of saying, well, yeah, those are my expectations too, right? And I think even in her case, it was on the line there. Expectations on what maybe you have to change it to meet other people's expectations, not only my own. So anyway, that's a great example. I won't go on into too many, but there are many examples of that, or viewed as this is a safety issue. This same safety issue that I think was brought up, I believe during the wrestling case, also are used in the employment context or a health issue, all things that there is no evidence that these things are needed. And if they are, well, then that is why it should be on the onus of the employer to suggest that there is some kind of business case, some kind of health and safety case, some kind of other emergent case for why this kind of discrimination must happen. But short of that, it should be viewed as racial discrimination, which all of us would agree that it is. So I'm really thrilled to see us here, and I hope, the Urban League affiliates, I think my next question is about that, so I'll wait. But we are really working because we're excited about what happened in the House. We're excited about what's happening in what 30 states, something like that. Maybe that's too many, but we really need the Senate to close the deal, because the states where it's not happening, where we don't have a state law, are where we need it most.
So you started to hint at it, but can you share with our audience more about the work that the National Urban League and its affiliates have been doing on the Crown Act?
Absolutely. So we were one of the founding members of the Crown Coalition. And the Crown Coalition is a coalition that has been focused on passing these laws around the country, and then ultimately building up to federal legislation, which is a classic strategy for civil rights advocates, as so everyone on this call knows. Laying the groundwork, removing any belief that this is about Moors in different areas. This is really about a national movement. And so the Crown Act, so in addition to Dove, which many of us are very much aware of, right? We also have Color of Change, as well as other partners. And I believe there are about 80 different partners, of which many of us on this group are a part of now. And we've been doing that work. And so we are very excited about what happened in the House, but there is a campaign, and I will put it in the chat. I think someone from my team is on who will put it in to make sure you have the Crown Act website. Oh, she's putting it in now. Crown Act website. She just gave me the thumbs up. Crown Act website, so that you can reach out to your senators. I think what the Congresswoman absolutely said is right. We need to be putting pressure on them and letting them know that this is an essential thing for us. It's a priority for us in a year where we've had some highs with Ketanji Brown Jackson, but some lows with, let's say, voting rights. That we are prioritizing this. We see this as a relatively low-hanging fruit win that we could have around civil rights that would, particularly benefit communities of color, including Native Americans and other populations of color, Latinx persons, et cetera. But as the Congresswoman already said, Black women best. Others will benefit in ways that they can't even imagine from this. We think about all of the uniqueness that we have and that we have seen coming out in these recent times as we're all owning our own individuality and changing the nature of what's viewed as professional and unprofessional. And the fact that you can do that now in part because Black women have been fighting for the Crown Act is something everyone can benefit for. So we're thrilled to have our affiliates, 92 of them, engaging here and to be working in partnership to really get the Senate to prioritize this. And it's great that the administration is excited about it. We need them. Eventually, we're going to get the Senate, but we also need the administration to let the Senate know, and Senator Schumer know, and Senator Booker know that this is something that matters to us.
Great. I'm going to interject one question from the audience really quickly before we move on to Brenda. I'm really excited to hear more about her work in Broward County. But a question was posed by the audience as to whether or not the Crown Act would protect non-US citizens or legal permanent residents. So if anyone could answer that question, that would be great.
It would. It absolutely would. Like most of our civil rights laws, you don't have to be a United States citizen in order to benefit from them. So that's actually a really, really good question. And Tony Wiley from the Urban League put in the chat, 14 states and 42 municipalities have passed anti-hair discrimination legislation. And you can visit thecrownact.com for more information.
And we are so lucky to have someone who worked on one of those municipalities and getting that passed, and that's Brenda. Brenda, can you talk a little bit about the work that you did in Broward County and also discuss ways that civic groups can mobilize on a local level to pass the Crown Act in their local municipalities and jurisdictions?
Thank you so much for that question, Phylicia, and thank you so much to the Lawyers Committee for hosting this and including me on this panel. I'm really glad to be here with you all today. As it pertains to how I even got involved with helping and aiding in the legislation being passed in my own county, is that I was a regular citizen just like anybody else. I really did not know too much about the issue. I really was brought awareness to it being involved in my local urban league and professional organization. And I'm south towards closer to Miami, so I'm not necessarily up in the Capitol. I'm not going up to days at the Capitol to be able to advocate. So I didn't necessarily see how I could be a part of moving the needle in my own local area. And it is through being a part, seeing the local Black Law Student Association at a local law school here in Florida, in Broward County particularly, that they coordinated an event. And I'm proud to say that Dr. Greene, you were on that panel in addition to Adjoa Asamoah. And it is through that conversation that one of our county commissioners, in addition to the chair over the Human Rights Council for Broward County, took that information and saw it right enough to be able to put it on an agenda to then be passed. And I had the opportunity to be a citizen who was able to speak in support of it, and it passed unanimously. But what mattered to really push the needle forward is us as being a part of civic organizations, seeing the need and seeing the connection piece between the law, between other civic organizations that connect with regular day-to-day people who experience it, who see it on the ground, and being able to convene that together. And, we didn't necessarily even think about adding in stakeholders or elected officials. I think we were only able to just bring forward the state senator who was sponsoring it at the time. But that was even out of my jurisdiction. So I didn't even know like how the moving parts would occur to really effectuate change within my local county. And the important thing I want to even mention to the audience listening is that it might seem minute, but I will say that out of the entire state of Florida, only my municipality, which is Broward County, has passed legislation regarding this. I actually had the opportunity to speak on a panel for a school called Johnson Wells, which is located in North Miami. And I remember one of the questions that I had received is that, so do you mean to tell me that if I step out of Broward County, I would be percepted or susceptible to being able to deal with that? And that kind of changed the needle a little bit for people to realize that, yes, we can see it's stuff that needs to be touched at statewide and also federally, but until that is addressed, cases will still come up. People will still be susceptible to those cases. And I think the regular day-to-day people, when they realize how great and powerful their voice is by being an advocate, not necessarily because you know the intricacies of the issue, but because you're emotionally attached and connected to the issue, utilizing that type of power to kind of galvanize not only community folks just as yourself, but even stakeholders who can move certain local policies, I think definitely has power.
This is Joi. Can I just augment one thing that I'd want to say here? This is also one in which Republicans can get excited about. Now, Lisa might be saying, Joi, come on now. You know, I'm always Pollyanna aiming for the silver lining, but you know, for if you are a conservative who in the past, right, notwithstanding these current days, but has found themselves middle of the road, having relationships with communities of color, this is a great issue for you. And so that's one of the things that we are approaching it. This is not, this is something that frankly, all good people ought to agree on. There's really no issue here. There's not an influx of cases where people will feel like, it's just not that kind of issue where this is going to be something where an employer has to be concerned about a lot of extra charges and losses. It's just not, it's just like not that kind of situation. This is purely about rectifying what most of us already know, is that if you're banning someone based on whether they're wearing braids or locks or something like that, you're engaging in racial discrimination. And most people, most employers, sophisticated, do understand that. And so this is helping them to work with any bad actors they might have within their communities who don't understand it. So to be honest with you, this should not be a difficult one. And so that's sort of the approach I think that we're taking. This is not, this is revolutionary in some senses, but really it's just codifying what we already know to be the case and what is already marching through state legislatures. Doesn't mean we're not ready for a fight, but we're hoping that this can be an opportunity for Republicans and moderates who want to do something good. This could be it.
And Joi, you kind of already started to touch on this, and I want to hear Brenda talk a little bit more about this, but if anybody wants to jump in after she's done, just what advice would you give to people who are listening to this webinar, either live or recorded, about what they can do to ensure that the Crown Act is passed either in their municipality or as we've been talking about, sort of on a federal level, to ensure those protections are extended to everyone within the United States. So I'm going to start with Brenda and talking about it from a local level, but then if anybody wants to jump in after that, that would be great.
Awesome. So for one, I would say really hone in on hosting events. I know for people take a lot of pride in the community affiliations that they have. And I know for a lot of folks, it's tantamount to give back to the next generation. And what we've kind of seen from these cases, it's unfortunately the next generations that has been affected by it. So I think what is critical and what could help along the way is really looking at it from a collaborative standpoint, looking at it from a collaborative standpoint that if you're a part of a Black MBA or if you are a part of a young professional organization, connecting with a barber, connecting with a beautician, even utilizing their space space to kind of convene community and include stakeholders, particularly stakeholders who have the wheel of a pen to be able to kind of draft some legislation or put something on an agenda. You don't necessarily have to have them as a talking piece, let the community be the talking piece, but allow them to be there to listen, adhere to it, and they can then utilize that to put that on an agenda. I would also say that encourage folks to even know who your state reps are, your state senators are as well. Even if you see from the 14 states or from the 42 municipalities, your state or your municipality is not listed, figure out who your person is who represents you and ask them if they know about it and if they would be interested in it. Or if something has been already filed, but it hasn't been passed, it died, find out who the sponsor is and reach out to them. I will say my knowledge was very limited in terms of even how it's progressed in Florida. It wasn't until when I had the opportunity, or I'm working on an op-ed through my internship with the Lawyers Committee, that I found out who the state rep is who has sponsored it. And just knowing the strategy behind why it necessarily didn't go as far as they wanted it to and what they could possibly look to do in the next legislative session. But in that way, and I'm not necessarily even in that person's jurisdiction, but I care about the issue that much to at least figure out how I can wield my voice within that. And so if you feel compelled through listening through this conversation, I definitely encourage utilizing those tips of the trade to be able to kind of move the conversation forward and hopefully move us to a point where we're able to get some national and universal protection behind it.
Well, Brenda, that was wonderful. Can I jump in? I don't know if okay, great.
Sure.
All right, wonderful. So that was wonderful because I don't have very many more suggestions because those are also comprehensive in terms of getting active on our local and state levels. And what I would say, even in addition to our state legislators, getting involved with our city council members. I imagine that most of us are probably maybe a little bit more close with and knowing who our city council members are versus maybe our state legislators and our federal legislators, but that's another avenue similar to what you've already done in terms of getting those city council members involved or even just speaking to them about it or bringing their attention to it. I'll say one of my former students is on the city council in Birmingham, Alabama. And, you know, it was by virtue of having conversations and her knowing about this work that I was engaged in that made it a priority for her to institute a resolution, just affirming, you know, the Crown Act and making a Crown Act a day in Birmingham, Alabama, which we know is the cradle of our more contemporary civil rights movement. So just even talking about it institutes change, right? On so many different levels, whether it be municipal or state or federal legislative level. But even beyond, I will say the legislation, though, is critically important, is that we can get involved in terms of reviewing our own policies in our workplaces, in our schools, as it relates to grooming and appearance, and reevaluating those to see to what extent is the language in these policies really being used as forms of targeting our students of color who are wearing locks, braids, twists, afros, bantu knots, not just African descendant students, but students of color. And that goes back to the question in terms of Indigenous students and Latinx students who likewise are being discriminated against and disciplined, as well as workers, right? And so revisiting these policies and making these organizations aware that these sometimes what we consider neutral policies, things that are sort of just commonplace, they really do have a real impact, a harmful impact on our inclusion in these spaces, have a real emotional impact, as Joi has already mentioned, emotional distress, physical distress, even beyond psychological, physiological distresses, because this is another part of it in terms of these grooming policies that basically bar us from wearing our natural hairstyles that are an expression of our cultural and racial and sometimes religious identities, especially for Black women and girls, is that this imposes what we're talking about is what I call a straight hair expectation or mandate. right? And so what are we doing to have to conform to the straight hair expectation or mandate or this pressure? We're using very toxic chemicals. We're using a lot of time and energy to try to go into the hair salons and the money that it involves getting a relaxer and getting your hair straightened and keeping it straight. And also on top of that, when we do it, what do? We don't engage in exercise and other physical activities because we spend all this money and time and energy to keep our hair straight. And that too has some impacts on our health, right? And so what I say about this is that to the extent we have grooming policies that either expressly bar natural hairstyles or implicitly do so by coding it as unnatural or extreme or distracting, which was the case with Deanna and Maya in Massachusetts. And the ways in which it targets us is that there's a health component too, right? And so to the extent that we are thinking about Black women and girls' health, when we are trying to conform to straight hair expectations and mandates, oftentimes what we're doing are things that are really harmful to our bodies and to our bodily integrity, to our psychological well-being, as well as our physical and physiological well-being. There are reports that talk about long-term use of chemical relaxants potentially having a correlation to our reproductive health. Higher rates of uterine fibroids amongst Black women, uterine cancer amongst Black women, and higher rates of productive hormonal reproduction or hormonal activity amongst Black girls. And so these are some of the things that I say when we're talking about trying to really address and advance the legislation, as well as even enforcement guidance that helps to support this kind of legislation, that when we're talking about viewing policy and legislation through the realm of Black women and girls, health is such an important part. And this bill is very much a critical part in terms of our health equity. And so when we're talking about the Crown Act, what I always say is that if you care about Black women's health, then you have to care about our hair. And so I think just utilizing this opportunity to educate people about the multidimensional nature of this discrimination. It's not just simply about losing employment opportunities and educational opportunities, housing, and other types of opportunities, which are critically important, but it's also really critically important to educate people about these other types of what I call invisible harms of natural hair discrimination that result or as a result of what I call straight hair expectations and mandates that are systematically imposed upon Black women and girls in workplaces and schools and other spaces.
Thank you. So we are coming close to time, and I want to make sure that we have enough time to sort of reflect and wrap up before the top of the hour. So I'm not seeing any more questions from the audience. So what I want to do now is just leave an opportunity for each of our panelists to just reflect back on the conversation that we've been having. And if there are any final thoughts that you want to leave with the audience, especially as it relates to advocating for the Crown Act on the federal level, but just any sort of final thoughts and reflections on our conversation today, if you could share that with the audience. And I'm going to start with Lisa, and then in my screen, it's Lisa, Brenda, Joi, and Wendy. So that's the order that I'm going to ask that we go in to just share our final reflections.
Thank you, Phylicia. And again, thank you to you and the Lawyers Committee for hosting this webinar today. I just want to sort of reflect on what Professor Greene was just talking about, and what it brings to mind for me is, the multitude of things that we as Black people have to deal with just in living our day-to-day lives, right? And the importance of, what I think she was highlighting is the importance of sharing that and educating folks about how this really plays out in the day-to-day lives for Black women and girls and Black boys and men, in terms of, you may narrowly think of it as this issue with regard to hair, but what are the ripple effects of that? And just encourage everyone to figure out ways to really get involved on this issue. I can't stress enough. I know that you hear from us all the time about reaching out to your um, your lawmakers or your representatives or your senators. But the reason you hear that from us all the time is because really it is, you are the folks that they listen to and respond to. And we do need your help on this issue. It is really important. I was thinking about Brenda's example of, so someone asking if I step outside of Broward, am I subject to dealing with this in other places because they haven't passed a Crown Act? And that's exactly why we need the federal legislation, because it shouldn't vary depending on the state or city you live in. I shouldn't have to live in a particular state to be able to wear my natural hair and not feel that I'm losing opportunities because of it. And so just to really encourage everyone, and I appreciate Joi knows we work on a number of issues together. I appreciate her optimism. I think it's going to be a little tougher than Joi is predicting. And so we just welcome and encourage everyone to really reach out to your senators and lift this issue up. And we will be, I'm sure the Lawyers Committee will provide the avenue for us to, folks to connect if they want to stay connected. But, we'll be sharing other opportunities and sort of key points of when we need folks to really activate with regard to the Senate. I would love to see us get this done. And I'm going to take a little bit of Joi's optimism, but I do think it'll be a little bit more of a lift. Yeah, so thank you again for hosting us today.
Lisa's absolutely right. It is going to be a tough lift. I guess what I'm saying is don't give up on Republicans. So many times when we do our advocacy, we will reach out to Democrats ad nauseum. People that are already on the bill, who already sponsored the bill, and they need the calls, right? They need to know it's a priority. But this is one, right? There are many bills that Lisa and I work on. I'm like, you can call them or not, but they're not, this is one where I think with some pressure, especially in areas where you have a disproportionate number of people of color, right? Where you could get a few are pickups. And so I do encourage you to challenge yourself, not to just go to the low-hanging fruit, but to also be looking at some of those Republican members and holding them accountable, because they're your representatives. So it is definitely going to be hard, though. She's absolutely right. I think we all agree on that. And just as I wrap up, one of the things I was thinking about, just to echo everything that's already been said, and I'm sure what Wendy will say, is think about if you're a white male, think about the things you don't have to think about. You're not thinking about, Lord, do I have to blow out my crew cut or my whatever? It would seem so silly. They're not thinking about that. They're thinking about other things. And we have to focus on so much foolishness. It's really not about our ability to do the job. And so when I think back to what our priorities were, when I was at the EEOC, reducing those barriers to employment, I was like, how can we remove things out of the way that are standing in the way of Black people, brown people, women being able to advance in the workplace? I think about my friend Stacy, who was a law professor at a school in the Midwest, and she was her first time teaching, and she got back her results. And these are future lawyers, 3 L's. And the main thing they got was that her hair was distracting. I had blocked that from my memory, but when he talked about distracting hair, she had an afro, right? So actually something that's protected by the law. These are the things, and it was hard for her to go back into that classroom, knowing that after a whole semester, that's what someone had to say. So it was very hurtful. And these are things that can hold us back emotionally. As I discussed, hold us back financially. And then sometimes, in some cases, actually prevent us from getting jobs through employment discrimination and promotion discrimination, right? We didn't talk so much about that. How many people are denied not just the opportunity to have a job, but the opportunity maybe to represent the top client, right? Because of perceptions on what is and is not, executive level look. So this is really an opportunity for us to turn the page as a nation, to step into a new moment. And so, you know, it's challenging America to live up to all that it should be. We have all of this diversity. There should be no barrier, and certainly not based on your hair. I look forward to everyone reaching out to their senator and letting them know this is important to us.
So this conversation was so uplifting. I kind of think about Professor Greene, how you kind of opened it up, talking about the difference between like immutable, and I found that to be quite interesting, something to kind of really think about as you even start to break it down for the folks who are not necessarily guided around laws and stuff, but are very much can see the discrimination apparent and very inherent in their own area. And I think when it comes down to what I made mention to related to community, a lot of this is kind of breaking it down to where it very much sits on culture more than anything else. It sits on culture and it's at this intersection of culture. And I think that is truly like the power that I feel that kind of keeps me optimistic through it all. I definitely believe, and I know it will be an uphill climb, because even some of the feedback that I had gotten related to my own state sponsor is that the initial thought process of the bill that she had to dumb it down a little bit, because there was a part where she wanted to include businesses, in particular, if you then discriminate against someone related to fines. And she just felt like if the language that she had, she just wouldn't be able to get buy-in from her colleagues on the other side of the aisle. And so I do believe, and I'm just even talking in the state context, so I can only imagine how it is even on the federal context when you're trying to also bunch that in, possibly in like an omnibus type of legislation. But I still believe in the optimism of it all, because at the end of the day, when we see the cases are still people. And I think when it's like you, in essence, for me being a community organizer, I see myself within the people. And so when it's still something that's so prevalent amongst them, there's no way where I can just sit on the sideline and not try to meet the people where they are, and even just kind of build some sort of community around that and empower them to feel like their voice can add value to it in some way. And lastly, I do just want to thank Joi for the shout out. I would not be connected with this work, I think, as much as I have, if it were not for being a part of the National Urban League Young Professionals movement. Something cool that I think prompted me to really get into it is that I sit on the advocacy committee for our National Urban League Young Professionals. And one of my advocacy committee members actually created a curriculum around this topic for our young professionals to go back to the young ones that we mentor, to be able to just tell them about, yes, you might be in a way subjected to it, kind of allowing them to kind of see the truth within it, but be able to kind of own what is in essence immutable. Going to use Professor Greene's wording with them. So I think that really kind of allowed me to own that space. And I'm thankful just for the opportunity to share this platform with you all. I really enjoyed it.
Alrighty. Well, I can just tell you my heart is really full just being on this panel as well. And thank you, Lawyers Committee, for just convening us all. And I imagine Lisa and I both, our hearts are full because we both helped to work towards crafting this legislation when it was first introduced, and to see, you know, to be a part of these conversations, greater levels of conversations and education around this issue that as Black people, we're very familiar with, but so many parts of our society just really were not even aware of it, or to the extent that they were aware of it, they didn't think of it as a thing, right? They didn't think it as being something that was harmful, as something that did constitute a systemic barrier to so many opportunities to greater exercise of our citizenship and full enjoyment of our citizenship and inclusion in our society. And so for me, when I think about all of the things that have been said and so beautifully said amongst my co-panelists, is that it really just reminds me of the words of one of my sheroes, civil rights lawyer, advocate, Pauli Murray, who has been an unsung hero in the civil rights movement, has been a legal architect of so many things as it relates to the civil rights movement, is that she said that the business of oppression is not respecting one's personhood. So the business of oppression is not respecting one's personhood. And I just hearken back to Joi's comments about how we can all rally around this issue and around this legislation, even if it's not something that directly affects you or you don't completely and fully understand, is that to the extent that you are committed to valuing the dignity, the full dignity and humanity and personhood and individuality and agency of all individuals, and ensuring that all the things that we bring to the table, our competencies, our qualifications, our brilliance, our joyfulness, our community to the table, then this is an easy piece of legislation to rally around, because if you're focused on all of those things, you're committed to those things, and you're committed to no longer engaging in the oppression of other individuals, then you absolutely should support the Federal Crown Act, because it is a piece of legislation that really tries to make sure that every individual, not just Black people, but primarily though grounded in our experience, but every individual's personhood and individuality is respected in these critical spheres, to our full citizenship and exercise of the rights that we have been afforded under our Constitution and other federal civil rights laws, as well as human rights laws. And so I will just say, everybody, get on board and let's free the hair. And again, thank you so much for having us all.
Thank you so much. And as we wrap up, I want to take a moment to once again thank Damon Hewitt, our President and Executive Director here at the Lawyers Committee, and Representative Bonnie Watson-Coleman for the conversation that they had that helped to set up this really dynamic panel. I also want to take a moment to thank our panelists, Professor Wendy Greene, Lisa Cylar Barrett, Joi Chaney, and Brenda Morrison for this wonderful conversation. And I hope that everybody that is listening to this either live via Zoom or is watching it back on the recording, feels empowered to go forth and advocate for the Crown Act, not only on the local level, but also feel empowered with the tools that they can go and push for this to be passed in the Senate and then signed into law. So I want to thank everyone again for their time, our panelists, our speakers, and to everyone who took time out of their day to watch this panel. Thank you again so very much. And I hope that you have a wonderful rest of your afternoon.